Hello, my name is Paula Caplinger, and I'm the Tidewater Area Manager and Counsel for Chicago Title Insurance Company, a division of the Fidelity National Financial family of underwriters. I've been working in real estate law for 37 years. When I was in law school, I thought that I wanted to be a prosecutor, but an internship at the local Commonwealth Attorney's Office quickly disabused me of that idea. When I graduated from law school, I went to work for a local law firm and worked in the real estate department doing title exams and real estate closings. I connected with the title agent that our firm used and saw what a difference that title agent made in resolving issues for our firm and its clients. When he was looking for in-house agency counsel, I jumped at the chance to join that agency team, and a short time later we were purchased by Chicago Title. As the old saying goes, the rest is history, and I've happily been a title insurance lawyer for the rest of my career. I genuinely enjoy helping agents and attorneys solve their title insurance problems so that buyers can realize their dreams by purchasing their dream home. And if I have just a small part in helping that to happen, then I think that what I do has been very meaningful. I met my co-presenter, Jim Windsor, when working at the law firm I mentioned. It's been a pleasure to count Jim as a friend and colleague for almost 40 years. Jim and I are going to share with you today on the topic of easements. So without further ado, let's jump right in. An easement is a privilege to use the land of another in a particular manner and for a particular purpose. An easement is not a possessory or fee simple interest in the land. The holder of the easement has a right to use the land, called the servient tenement, but has no right to possess the servient tenement. The landowner of the servient land may continue to use that land in any manner that does not interfere with the use created by the easement. Easements can come in many forms. Some examples include an ingress-egress easement that prevents property from being landlocked so that the easement holder can get to the public road. Easements can be for water. They can be for sight. They can be for view. Easements can be for light and air. Easements can be for utilities or landscaping or common elements or recreational activities, conservation purposes, parking, or repairs. Easements can be created in many ways. They may be express, which means created by a written instrument. They may be implied, which means created from a plat or a map or from a prior or existing use. They may be created by necessity or by estoppel or by prescription. All easements, no matter how they're created, have certain attributes that define them. First, easements are defined geographically. How wide is that easement? How long is it? What shape is it? An easement may or may not have a discernible location. Second, how long does that easement exist? Is it temporary or is it perpetual? Does it go on forever? For instance, an easement by necessity only exists so long as the necessity exists. Other easements are perpetual unless they're abandoned. Third, easements are defined by the way that they're used. Is the easement used for a certain purpose, such as access by a car, and therefore restricted? Or is it unrestricted, so that easements may be used for any purpose for which the dominant estate is currently used, so long as the easement does not add an additional burden to that dominant estate. And finally, as I've stated, easements are not ownership interests in land. Easements are purely the right to use land. An appurtenant easement benefits the holder of the easement in his physical use or enjoyment of another tract of land, called the dominant or the dominant estate. So there have to be at least two tracts of land, the dominant land and the servient land, when there's an appurtenant easement. According to Virginia Code 55.1-303, the benefits of an appurtenant easement attach to the dominant estate and run with the land and pass with the title to the land, unless they're expressly excluded from the conveyance. There can be no conveyance of an appurtenant easement separate from the dominant land. The holder of that easement can't just decide that they want to grant or convey the right to use that easement to a third party for the benefit of some other person or some other tract of land. An easement in gross arises when the holder of the easement acquires the special right or privilege to use the land of another. An easement in gross is separate and independent of any ownership interest in land. There's no one dominant estate and no specific property that's benefited from the easement in gross. For instance, an easement in gross is a public utility easement. It benefits many parcels of land, not just one parcel of land. Easements in gross are usually assignable, so long as the whole easement is assigned. And the only exception to that, where an easement in gross may be apportioned or split up to sub-easement holders, is when broadband or communication services are involved. And that's pursuant to Virginia Code 55.1-306. Now that I've covered the basics of what easements are, let's talk about how easements are created. Easements may be express, which means created by a written instrument, such as a separate easement document, or an easement may be part of a deed, but it's still in writing, and it may be granted in that deed. An example of an express easement is when A owns Blackacre and gives B, his neighboring landowner, a written deed of easement to cross Blackacre to get to the public road. The document creating the easement has to comply with all the formal requisites of a deed. A plat alone is not a legal instrument, and by itself it cannot create an express easement. There has to be a clear intention on the granting document to create an easement. The more specific the wording, the better. The purpose is to provide future owners knowledge of that easement. And what that means also is that the easement needs to be recorded in the land records so that there's notice not just to future owners but to anyone that there is an easement for a particular piece of property for a particular purpose. Unfortunately, a lot of folks forget to record written easements. And then that creates all kinds of problems in the chain of title and all kinds of issues that have to be resolved. So a practice tip, if you're preparing an easement, make sure that it is actually recorded and make sure that it meets all of the requirements of a deed. Before you ask a title insurance underwriter to insure together with an easement, the title to the land over which that easement runs has to be searched, not just the title to the tract of land that's going to benefit from that easement. It has to be verified that the grantor of the easement actually owned the land, not that they just had a lease or a right to use that land. They actually have to be the fee simple owner before they can grant the easement. The easement has to be described in some fashion. It has to be shown on a survey or shown on a plat. It has to be ascertainable. You have to be able to figure out what that easement is. And it should be included, if it's not by a separate instrument, it should be included in the current deed and the current deed of trust. So there's another practice tip. Including it in the deed is good. Including it in both the deed and the deed of trust is preferable. Appurtenant easements, as I mentioned, do run with the land. And as I've mentioned, it's a good practice to have that together with in both the deed and the deed of trust. Now let's talk about some problems with express easements. Okay, first, if there's an open, unpaid deed of trust that's burdening the servient estate at the time that that easement is created, but everyone forgot to get the lender to join in on that easement, that's a problem. Second, the language creating the easement needs to be clear and unambiguous. If it's not, then how do we know 10 years from now the true intention of the parties as far as that easement being created? And that's when a court has to step in sometimes and determine what the easement really covers. Was it intended to be forever? And do you really want to have a court substitute their understanding for the intention of the parties? The third problem with express easements, when the easements that granted doesn't actually match what's on the ground. 4, what happens if an express easement's blocked or obstructed? Does it even still exist if you can't drive over it? What if an express easement has been extinguished by merger or abandoned? And finally, what if the parties, as I mentioned, forget to record that easement? All of those are problems that can happen with express easements. Besides being created by an express grant, an easement can be created by implication. Implied easements may be implied by a plat or implied by circumstances, such as by a prior or existing use. There's a great case that you should note called Lindsay v. James at 188 Virginia, 646, 51 Southeast 2nd, 326, from 1949, that holds that when land is subdivided into lots, the streets and the alleys and the lots are all sold and conveyed according to that plat and without any reservations on that plat, then the conveyances carry with them the right to use those streets and alleys because that's necessary to enjoy the lots that were conveyed with reference to the plat. Purchasers that acquire title to those lots are presumed to be interested in all the streets and all the alleys that are shown on the plat, and so they are presumed to have an implied easement to use those streets and alleys. However, this is a presumption of fact that can be rebutted by a court. And it's going to be a case-by-case situation as to whether a title insurer is going to be willing to rely on an easement by implication to ensure access in a title policy. Easements by implication may also be created by a specific set of facts or a specific set of circumstances. The theory is that if a deed doesn't say otherwise, then the grantor conveys everything necessary for the use and enjoyment of the property, which by implication may be an easement over an adjoining piece of property. The elements of implied easements have to be proven by clear and convincing evidence. The easement has to be continuous, apparent, reasonably necessary for the use and enjoyment of the property conveyed, and in existence at the time of the conveyance. An implied easement, an example would be if someone's conveyed property beside a lake, and there's nothing that mentions that they have a right to cross adjoining property to get to the lake, but it's kind of assumed that they have the right to cross that property, and by implication have a right to use that easement to get to the lake. Just like with express easements, there can be problems with easements by implication. The level of necessity that has to be proven is uncertain, and the burden of proof is on the party that's trying to prove that that easement actually exists. It's often difficult, if not impossible, to prove somebody's intention 20 or 30 years ago in a court today. The parties that initially did the conveyance or the parties that created the easement may not even be around to come to court to testify. So easements by implication are more difficult to prove as time passes. Another way an easement can be created is an easement by necessity. An easement by necessity arises whenever it's evident from the circumstances that the parties intended to create an easement. Landlocked property is disfavored as a matter of law because it makes the property impossible to use. So an example of an easement by necessity would be if Dad devises land to his two sons, and then the two sons subdivide the property. One son gets an interior parcel, and the other son gets a parcel that runs beside the public road. Well, there's an implied easement over that outside parcel for the interior parcel owner to reach the public road. Easements by necessity are even more difficult to prove. The critical elements of that easement by necessity have to be proven by clear and convincing evidence, and they include common ownership of the land at some point in time. The unity of title, that common ownership, must have been severed. So when Dad passed away and conveyed the property to the two sons and they subdivided it, that severed that unity of ownership. The severance has to give rise to the need for an easement. That interior parcel had to have an easement to get to the public road. There has to be no other reasonably available access to a public road. So if the interior parcel owner had had another way to get around to the public road, the courts would likely find there was not an easement of necessity. And the problem is establishing that unity of title, establishing that severance of title, proving that that severance created a need for that access by necessity, or establishing that there really is even a need for the easement, period. So our example was pretty straightforward, but easements by necessity are not always that straightforward. And to prove those elements by clear and convincing evidence can be very, very difficult. Thank you for your attention. Now I'm going to turn the program over to my colleague, Jim Windsor, to discuss creating easements by prescription, easements by estoppel, the location and scope of easements, and how easements may be terminated. Take it away, Jim.